and then researching. We have new people here, so it's hard to know how far back to take this conversation. But we have, over the past few years, we've talked about amending the zoning code, and we have proposed amendments to the zoning code. I think probably everyone else here, maybe Dan doesn't have it. So I put them in a local law format, but the last time we went down this path, the effort ground to a halt. So before I reach out to law firms to try to get quotes, how much it would cost the town to help, how much they would charge the town to help us enact these zoning amendments. I just want to make sure that any of them have majority support of the board.
Well, at the last meeting, we had talked about that the 30 feet would be natural vegetation. That would be left at natural vegetation under the general guidelines on second page, under section 6.
Okay.
So we had not the improved or adjourned, we said we'd leave it at natural vegetation, was my understanding.
Okay, I don't remember that, but
We did mention screening quite a few times.
For the dumpster, for something else? No.
no, it's section 6.
Okay.
Oh, yeah, right.
That's the next sentence. Section 6, the last sentence of section 6 is what you're talking about, I think.
It does say at least 30 feet of natural vegetation shall be left in its natural or improved state.
So you're saying delete improved?
Well, that we had, my understanding, we were leaving it in natural. Was it under the other improved state, or was it
I thought we had just discussed
left in
basically
natural?
a 30 feet buffer, because sometimes there's not any vegetation. Sometimes there is vegetation, and I thought we had talked about 30 feet of just of a green area, basically in between.
Well, I guess that would be the or improved. That would.
And it does say that the zoning and planning boards each could require additional measures to add additional screening.
Okay. Which is some of these things that this is why it seems almost monotonous to me, because they already have the right to do that. That's why we have a zoning and planning board, and they can request screening on any project.
That's true. That's totally true. Putting it in black and white and in text and in the code in this way, I think just reminds them and reiterates. It is what you're saying is true. I'm not sure that everyone is always aware of that.
And then I had asked a couple of questions last time, and nobody really gave me an answer, but now it's kind of saying it. It says 8,000 total feet of floor area, and nobody really gave me a definite, and now it's saying in one building, more building, and 40 feet of the outside. So if there's a 2-story building that goes up, we can only have a 4,000 square footprint, I take it?
No.
Well, that's what it says.
Got it. Now I understand. So if there's a 2-story retail building.
Or any type of business building.
It's retail. It's
what's
solely
considered retail? I mean, that's...
It's defined in the code.
So is a hotel considered retail?
No, I don't think so. I think it... Well, hopefully it's
I
defined
think
in the
it's
code.
sale of goods and services.
Yeah.
And I had also mentioned a place like Hazelton's, and your argument, both of your arguments to me were, well, that's what variance is before. But we've also been at other meetings where you've sat there and said, variances are basically favors. They should never be given except in extreme circumstances. But now when I bring up something like that, oh, well, they can just get a variance for it. It's like, well, is it extreme circumstance? Or can they just get a variance anytime that they need it? And a lumberyard would be a situation where, well, is that an extreme circumstance? Do we need another lumberyard in town, or does that lumberyard need to stay? The answer is always like, well, get a variance. But variances aren't guaranteed. Variances are basically favors.
Okay, Tim.
Retail use establishments providing goods, merchandise, or services to the general public for a fee such as, but not limited to, banks, educational services, gift shop, dry cleaners, laundromats, supermarkets, and food stores. Surprising that educational services is in there, but
Yeah, since we don't have any schools.
the others are, I think, within. The other examples are within what anyone would conceptualize when they hear the word retail. So supermarkets, markets.
I mean, I dare say, and I'm not sure, but
Can
I dare
can
say that.
Darren,
No, wait, Darren.
I wanted to finish what I was saying. I had another point to make.
Go ahead.
Thanks.
Quietly.
Simply, variances should not be favors. The criteria that a planning board or a zoning board uses to evaluate a variance is spelled out, is a state law, and is spelled out by the state and in our zoning code.
Mm-hmm.
So it's not a favor. There's
They have to meet a
specific
test.
criteria. Yeah.
So if,
Okay, Darren's turn.
I'm good.
Yes, go ahead.
So if a lumberyard was to be bought, they have to apply for a new business permit. Giving our code, it says it's not allowed. What would be their circumstances, because it's not allowed, that says this permit is a given?
Laura.
That runs with the land, not with the owner. It is already, if it's a pre-existing thing, it runs with the land. The special use permits, the variances run with the land, not with the owner.
Well, how come every time a business changes ownership, it has to go for a new special use permit and a new business permit?
Did Hazelton Lumber, if we're talking about lumberyards, they recently changed hands, and I paid pretty close attention to the planning board, and I'm almost positive that they didn't need a new permit, right?
Well, okay, so there are a couple ways of doing it. If it's a changing of the ownership, I think, if it's in an area that's a non-conforming use, if it's a change of actual ownership, so it goes from favor to Laura, then Laura would be obliged to apply for it. If you're purchasing the company, so you bought Hazelton Lumber Inc.,
Mm-hmm.
that's not the same change as ownership. What you've done is you bought the company. So a deed may not have been given. I don't know. That's a possible explanation.
Special use permits, area variance, and use variances all run with the land.
So,
But not a business use permit.
That's not what we're talking about. We're talking about whether or not they can run a lumber mill, which is a use.
yeah.
They probably predate our zoning code, so
Yeah.
they would have been grandfathered in the first place.
That is only the change use.
Not in the same being a corporation or an LLC brings in
Well,
extra laws that
No, but
change the whole thing.
they just didn't change who the actual legal owner is. Yeah, it's one of those things that totally amazes me. And I realize this is that Wilmington doesn't really have a zoning code. It doesn't zone. It is a land use code. So it tends to focus its inquiry on what's happening on the land and whether a permit should be issued, a special permit should be issued, whether variance is required for what's happening on the land. One of Bill Wonderland brought up the question of the land use code actually has a way of doing conservation subdivisions.
Mm-hmm.
But where? Where in the town would they suggest to the town planning board that this is the time for you to be starting to look for?
The homestead housing. It's a
Well,
prime example.
but I'm just saying, but where in the code? Right?
It's in there. It's under plan development.
Yeah, but it's a use. It's not an area of town.
No, it's anywhere in town,
Exactly.
wherever that there's a
Exactly.
subdivision.
So that's the interesting thing about it. The zoning is, I think, an idea of the town has said, listen, this part of town is where we would like to see agriculture. this is the part of town where we would like to see industrial development. This is the part of town where we would like to see conservation in a cluster conservation subdivisions used. And so we don't really have that. We have, here we go, should everyone, a part of the, the conservation requirements that came up because of what happened recently on Hardy Road. And so there's nothing that tells us, you're on Hardy Road, it's time for you to look at doing one of these subdivisions. So Tim had his hand up first.
Thanks. I think of land use codes and zoning ordinances as synonymous. How are they different? When you say we have a land use code, not a zoning ordinance.
Because there are no zones exactly. What we've done is we have hamlets, and then we adopted the APA specifications for moderate intensity use, and then inside of those uses, we put the types of things that we're going to permit without any review, or we're going to need review, or all that stuff, and it has to work with the APA. But it isn't an expression on behalf of the town that we would like to see multiple family affordable housing in this area of town or something like that. This is residential. We could kick the STRs out, and we don't want to see them in town. So they'll be forbidden in a specific area of town because we've zoned it that way. And we can say, well, we'll allow you to have them over here. That's what zoning is. What we've done is we've got one big town, and we're telling you what each, what you're more or less allowed to do within each part of town based on the land use count, what you're going to do on the property. That's all.
Do you think of the previous code as more of a zoning ordinance?
Well, we uploaded the 1975 master plan online, and I included all of the maps as an attachment to that, so it's on our website. And you can see what they're looking for. They're looking to say, okay, so this road here is residential. Okay, well, you have to have a darn good reason why you're going to try to seek an exception for residential. If we say, okay, this is R1, no short-term rentals in R1. So if somebody's got one, it's grandfathered for a little while. That's why I don't think it necessarily runs with the land. Once it's gone, it's a non-conforming use, and then the non-conforming uses get eliminated by the zoning because they don't want it in that particular area. And so, to me, I'm not sure what happened with 2011.
2000, right. I think Randy very candidly said that it was to spur growth and development.
Well, that's fine.
That was the purpose.
I'm only looking at it from the point of view of what I can find and try to read up on.
This was an article in the Press Republican that he is quoted as saying that was the purpose.
Yeah, but that's it was at the town's idea too. So anyway, that's kind of what I and I've sort of looked at this this way, and I'm thinking. Still, I know I harp on about zoning for a year, but it seems to be sort of the missing tool in the toolkit for the town to really regulate the uses in certain areas a little better without necessarily being sort of in this area. Oh, it sounds like a good idea for us to do a conservation subdivision.
So,
go
can
ahead.
I touch on that?
Sure.
So I'm not making up the running with the land.
No,
definitely true. All three of those things. That's true. And also regarding the conservation subdivisions, the planning board has the right to request a developer to come back with the recommendation saying, we will work with you to decrease the setbacks in these areas if you can make a more compressed development and have this area that you are using for a leach field or otherwise, and it would be something that is broached by the planning board or I guess at that point it would be the zoning board of appeals, but
yeah,
it is something that I don't think we utilize it, but it is part of our code.
It is, but what because it would help both the planning board and the property owner to know that they now own 150 acres in an area where if I'm interested in subdividing it, they're going to be asking me about a conservation subdivision. And that's part of the overall zoning idea. if it becomes kind of, by the case, so I did it over here and I didn't do it over here because the planning board personnel are a little different, have a different approach. Tim?
The idea in 2011 was to simplify the zoning code by just making everything the same, the zones the same as the APA land use classifications.
Right, yeah.
So it's much simpler and straightforward. Whether it's good or bad is any individual's particular belief system. But so I'm not. Should we vote on these proposed amendments to see whether any of them have support of the board?
So I will tell you right now, my concern is section 5. Special use permits shall not be granted if the proposed uses will have a material adverse impact upon or a clearly adverse aesthetic impact upon the town of Wilmington.
Mm-hmm.
Well, that's kind of subjective what aesthetic is. And also the town of Wilmington. So if I have something on the far end of Bruce Hare Way, and it's not an aesthetic of Wilmington, I'm going to say that somehow or other somebody could deny the special use permit because of how ugly it is in relation to where the Hungry Trout is. That's the town of Wilmington. And so that's the kind of, that I would see if I could tighten that up a little bit. I'm thinking what we should do is people write up between now and the next meeting, proposed comments for this, and if it's ready for the next meeting, we can go to, if the board wants, the lawyer or something like that. Is that all right? Because we're talking out loud about this like that, which is fine.
Just with aesthetic, the word aesthetic is used 6 times in our zoning code, including on the first page. And it's, when someone says that it makes an adverse aesthetic impact, it's not just one person or 3 people saying, I don't like the way that looks. Like the planning board of the town of North Elba, they did findings of fact and they did visual impact studies. And there was 16 pages of research related to noise and traffic and visual impact and screening and all the rest. So aesthetic, it does seem subjective, but as Favor and I know, the law is shot through with subjectivity. The law is not black and white. It is subjective. And the word aesthetic, it's in our zoning code repeatedly, including related to like special use permits, site plan review. So adding the word aesthetic again, 7th time, I don't think is a big stretch, especially since it's what allowed the town of North Elba to deny the permit to Walmart.
Tim, can you remind us what it says now? Because I know there was just like, we're going all through this because of one word. Rather than material adverse, and right now it's subdue adverse or some...
Undue.
Right?
Undue
So
adverse.
we're going through all this to change undue to material, like, correct?
Correct. Because undue is much more vague. Who knows what undue, again, that is subjective. Who knows what undue is? We all would see that differently. Materially is much more clear and easy to define. Related to the screening, I just wanted to mention, it is implied in our code. I'm not sure if it's spelled out that our planning board can require screening. It probably is in there, but putting it in here again as an amendment would remind our planning board they can do it. If they don't know, it spells it out if it's not in there already, and it gives the planning board stronger legal grounds to require it.
Anyone else?
And the last thing that I know Tina had brought up last time that we had talked about, the dumpsters, and that was, for the most part, everybody agreed, but there's certain situations where you literally can't be 20 feet from a property line or a public roadway, and Fratelli's being one of them. And what would we do with a dumpster if we can't put it in those locations? And there's never any answers to this other than they can get a variance, and that's always the answer.
I think, unfortunately, the answer to that is, fortunately or unfortunately, since this is all inspired by a particular dumpster that's not that dumpster, is that the existing uses are grandfathered in.
Until that business changes hands, and then it's no longer.
Yeah,
Yep, exactly.
Well, we're back to that circular point.
Well, it runs with the land.
Okay, so what would we like to do? Tina, what would you like to do next?
Does it run with the land if it changes the use?
You'd have to ask for another use variance. You'd have to get a use variance if it's not part of the code.
Wait a minute, we'll be going to the attorney at some point soon, so we'll ask Mark.
Believe
If
so. Could be wrong, I don't think.
I wouldn't think that would run with the land if it changed. What do you
Well,
mean?
that's
What do you
The
mean?
business changes its use.
But you mean the new business or the existing?
The existing business, if Fratelli's changes to a different business,
Yeah, but start again.
I would think that wouldn't.
so,
That's a new use.
Let's
Yeah.
start again.
so then this wouldn't,
I'm sorry. This is, what would you like to do next? 'Cause
well, I
Suzanne would like
would
to
like
do-
to review it and bring it to the next meeting.
Okay, thank you. Darren, what would you like to do next?
As it stands now, I'm voting no, and I'll just leave it as that.
All right, fair enough. Laura?
Make edits, bring it to the next meeting, and then decide if it's a move forward.
Sure. Okay, Tim, I'm sorry, I agreed with you.
I think it's good as written. However, as long as we seem to be making forward progress,
Okay.
I think that's positive.
Thank you. So I'm sorry, move fast. This is public comment, Suzanne. I'm sorry to, you notice, you could talk to us, please.